Good morning, my lord.
Good morning to you.
I note that it is 10:38, so I hope that we can sit until 12:08 in terms of the hour and a half I was promised yesterday.
Well, that depends if you want to use the whole 90 minutes for what's
It depends on how much we debate,
It's
my
up
lord.
to you. You carry on.
Yes, thank you, my lord. May I start with housekeeping, please? We've prepared overnight an additional supplementary authorities bundle. Some of these authorities were mentioned by our learned friends yesterday, but were not included in their authorities bundle. And then some of them are new authorities, which I shall refer to in the context of my reply. So I beg leave to hand that up. But before the registrar comes forward, maybe I can deal with all of the things I'm handing up. The second bundle that I'm handing up are the foreign parliamentary issues that I started reading yesterday.
That's with Boris?
That's correct.
Yeah.
That's correct. And what you will see in the index is that because some of these documents are voluminous, we've indicated where we read from, or where I read from, so that the court's attention is directed, and our learned friends, in the event that we want to file supplementary notes or whatever, as foreshadowed yesterday. The third bundle of documents I'm going to hand up is an extract from the Rules of Parliament, which is the new section, the new Rule 129, which deals with the removal of a Chapter 9 office bearer. And I'll develop some submissions on that in due course. I beg leave to hand up the documents. I've obviously given copies to my learned friends.
Justices, if I may just address the foreign law issue. Yesterday, there was a suggestion that we may file a note. May I make it the following suggestion? Is that we will consider the foreign authorities and we will let the court know, with leave of the court, whether we intend to or do not.
Well, that's right. We'll need to consider whether, in fact, these are really relevant
Yes,
in the grand scheme of the debate.
Yes,
But I'm not going to say anything about that. I shall leave it to you to make that judgment call.
yes, as the court pleases.
So,
Thank you. Carry on.
there are three principal submissions I'll be making today. The first one is the context and scope of the challenge, and a lot of what I'm going to say emanates from the debate that I had with the bench yesterday, and primarily Justice Davis. Secondly, I will talk about the constitutional relief dealt with by Mr. Nasiruddin, and thirdly, I'll talk about the review relief. So, can I turn to topic number one, the context of this case and the scope of the challenge? Please can I ask the court to turn up the authorities bundle in the hard copy file that you had yesterday. It's called Applicant Supplementary Bundle of Authorities. And can you please turn up page 234 and 235 of that authorities bundle? This is the Lord judgment.
Yeah.
Because you'll remember right out of the blocks, Justice Davis, you were pointedly referring me to paragraph 21 and suggesting that paragraph 21 creates a precedent problem, and that this court can only depart from this judgment in instances where it is palpably wrong.
Well, only in relation to one question.
Yes, I accept that, and you'll remember I gave you two answers yesterday that the reason that this case is distinguishable is because of EFF2 and the frontal challenge.
Yes, which we will consider.
Yes, please go to paragraph 16 on at page 234 of the judgment, because paragraph 16 is a complete answer to Justice Davis. And
paragraph 16 of what?
Paragraph 16 of that same judgment, page 234 of the authorities bundle that I referred to. This is the EFF Glodlaw case. Sorry, it's the EFF case versus the Speaker, where Justice Glodlaw wrote the majority and Justice Bozilek dissented. Let's look at paragraph 16 together. I'm reading from line 3, because this is the summary of the applicant's challenge, which is not the same in this case, and therefore this case is distinguishable both on the facts and the law. It says, it has been mentioned that the applicants alleged that the composition of the committee rendered the disciplinary proceedings unreasonable and procedurally unfair. And here's the kicker, in that the committee could have been reconstituted to ensure political balance and fairness. We've not pleaded that case at all. We're not asking about
this is
reconstitution.
the problem which I had with you yesterday. Please go back to 21. And let's read that.
There.
There is clearly no room for a further delegation of these powers to yet another body.
I'll address that shortly. I'm
Well,
currently
that's the
just
central.
dealing.
No, sorry.
I'm currently
No,
just
but with
dealing.
respect, that's the central question. So address
I'll
that.
deal with that if I can develop my submissions. I was in dealing with the original point you
I'm
put
not
to
sure
me,
that's
Justice
gonna be
Davis,
helpful.
regarding the issue of whether or not this
Mr.
judgment
Brennan,
stands in your way
you
of
need-
making a judgment.
You can say what you like. I'm quite happy about that. But the critical question.
Thank you, Judge.
is
I'll come
to-
there if I can develop my submission.
No. The way advocacy works is you reply to the bench. Now I'm putting to you, it's 21. The other's got nothing to do with
I'm
it.
going to come there, as
All right.
I've said repeatedly, and the point is I'm replying to the question you raised with me yesterday, and paragraph 16 is the direct reply
Well, my
to
view
the
is it
question
doesn't
you
do
raised.
that at all.
That's your view, which you are perfectly entitled to,
Thank you
Justice
very
Davis.
much.
I'm just making the submission as
I
I'm
hear your
entitled to do.
submission. Let's move
That's
on.
the first point.
Yes, what's the second
I
one?
don't know, there's some noise from behind. Did someone say something? No.
Don't worry about them, just
Yeah,
worry
I'm
about
not
me.
worried about
No.
them. The second distinction between this judgment and the other is look what the sentence goes on to say.
Which sentence now? Which
I'm
paragraph?
now reading, I've just completed that sentence in paragraph 16, starting at line 3. I'm now reading the sentence after the full stop where that sentence concludes. It says, in the alternative, it was argued that the matter could have been chaired by an impartial person such as a retired judge. That's not our case. So that's why this case is distinguishable.
What is your case if it isn't that the issue that we dealt with is that you wanted an impartial person to be the fact finder?
Yes, and that's at odds with what
And
this
the
case
answer
was
is
about.
that, therefore, if you read that with 21, it's the complete reply.
Yes.
And that's all I'm saying. And therefore, we don't go any further. So let's move
I'm
on.
not going any further.
Very good.
That's the point of the
All right,
submission.
so let's get on to the more helpful part.
This-
Carry on.
well, maybe this is an additional helpful point to Justice Davis, and in the context of Justice Fortain, because you'll remember Justice Davis spent quite a bit of time yesterday saying to me that the logic was that we were attacking 3/4 of Section 12, and we didn't go the full step to attack Sections 12.1, 12.2, and 12.3.
Well, that was your opponent's
Yes,
argument,
that's
not
correct.
mine.
That is
Yeah.
correct. I didn't suggest otherwise.
Yeah, carry
and
on.
then the second point is that Justice Fortain will remember in the context of that debate, Justice Fortain, in the nature of discussing parliamentary democracy, both with me and my learned friend, said that's just the nature of the beast, right?
Yeah.
So the point I'm making is that I'm under no obligation to challenge more than what we've identified in the proceedings.
No, that's fine.
And the authority for that is Fisher versus Ramatlele, which is the SCA authority. It's in our additional supplementary authorities bundle. That's the one I handed up this morning. And in particular, I'll ask the court to look at paragraph 13. However, in particular, I will ask the court to please look at paragraph 14 in
Of
particular.
what? Of what?
Sorry, my lady, it's Fisher versus Ramatlele
Yeah.
in the additional supplementary
Yeah.
bundle, the one I handed up this
Page,
morning.
related page.
114
Yeah.
is where it starts. The court can read 113 because that talks about the issues of the parties and what they identify in their challenge. But I think it's important to read paragraph 14. It is not for the court to raise new issues not traversed in the pleadings or affidavits, however interesting or important they may seem to it, and to insist that the parties deal with them. The parties have their own reasons for not raising those issues. A court may sometimes suggest a line of argument or an approach to a case that has not previously occurred to the parties. However, it is then for the parties to determine whether they wish to adopt the new point. They may choose not to do so because of its implications for the further conduct of the proceedings and so on. And the point here, which this concludes, the SEA concludes, that is for them to decide and not the court. If they wish to stand by the issues they have formulated, the court may not raise new ones or compel them to deal with matters other than those they have formulated in the pleadings or the affidavits. So insofar as
and the point being?
The point being that insofar as this attempt to suggest that our logic insofar as what we do challenge is flawed, because we didn't challenge the entirety of the section, is quite frankly disavowed by the SEA.
No, that's not what they're saying. What I'd like you to address me on is what they are saying. And what they are saying is this, that if you go to the balance of Section 12, it has a structural framework in which there's a structure as to how this is dealt with. You haven't attacked the structure, ex definizione, because of the fact that the structure envisages a committee, etc. You haven't attacked that. Therefore, their argument is the whole issue of bias in
Yes.
relation inherency.
I'm coming there.
But that's the point. Nothing to do
I'm
with
coming
this
there.
judgment's irrelevant.
I'm-
That's their argument.
With all due respect, I'm coming there, but I'm just demonstrating
No,
why
but
this
all
attempt
I'm
to...
saying is I'd like you to
the-
address
the
their
attempt-
argument,
the attempt to,
not a make-believe
the-
argument.
The attempt to impose the burden as a response
No
to the
burden
attack
at all.
that we... The attempt to impose the burden by our learned friends to attack the parts of the section that we chose not to attack for the reasons in the gift of the parties is what the SCA says we're perfectly
I
entitled to
understand
do.
that perfectly,
Thank
but
you.
that's
Then I'll
not,
I'll move
again,
on.
may I say, that's not helpful.
Okay.
What is helpful is for you to address their submission,
That's
which is the
what-
one I
that's-
need to get an
That's
answer.
what
Carry on.
But firstly, I'm addressing it
I
as
know
a
that,
matter
I'm
of
just-
procedure.
I'm parking
I'm
that
coming to it as a matter of substance.
Okay.
If I can
Sorry,
develop the
if you just
proceeding,
say that-
I'll do
sorry,
that.
Mr. Brahman, just listen to the bench and you'll get plenty of opportunity.
I'm listening very well, my lord.
So just quiet for a moment. And let's just reduce the temperature. And let me just say to you, the key submission, which is what you have to answer, is their submission, which is not that they're saying you should have pleaded X, Y, Z for the question is, what does it say if you don't attack that in relation to the structure which has an inherent
Yeah.
component
And as I've
of
said,
majoritarianism?
and as I've said repeatedly, I'm coming there.
Well, that's what I'd like you to come
Thank
to
you.
right now.
Well, as it so happens, I'm coming right there,
Well,
right
very,
now.
very good. Well, then
Right.
do.
So the third sum point that I'm making under this first issue about the context and the scope of the challenge is the issue of the tyranny of the majority.
Yes, okay.
Because Justice Davis says yes, so finally...
That is
we
the
can
point,
speak
yes,
directly
finally,
to each
yes.
other. So thank you. So insofar as the tyranny of the majority is concerned, you know what my submissions are flowing out of EFF2. I'm not going to repeat them. Can I give you two additional authority references which add further scope to the tyranny of the majority,
Sure.
however it is constituted, whether by single party or a coalition? Before we get into a debate about whether these facts are entirely foursquare or not foursquare, let me say upfront, the facts are not entirely foursquare. Instead, I'm looking at the ratio of the court and saying that that is persuasive here in respect of how the majority operates. The first case is Oriani Ambrosini versus Sisulu, Speaker of the National Assembly.
Is that in your new
Yes, it
Bible?
is, my lady. Can I give you the paginated page
Yeah,
reference?
please.
196.
This is the additional supplementary.
Yes,
Yeah.
the one that I've handed up this morning.
Okay, yeah.
196 at paras 64 and 65. The court may be familiar with this case. This case was about whether or not Ms. Mazibuko, Mr. Oriani Ambrosini, as an opposition individual member of parliament, had the ability to raise a private member's
Yeah,
bill,
yeah.
Yes,
which was
yes.
subject to the permission requirement in the programming committee, and the tension in the court was whether or not the protection afforded to the MP
Yeah.
in terms of the constitution could be subject to majority permission.
Yeah.
So at para 64 and 65, the portions of the paragraph I'll highlight, which we say is persuasive in this case in respect of the tyranny of the majorities, as follows. I'm reading in 64 from line 3. Further public participation so as to cultivate an active, informed and engaged citizenry is also facilitated by rules that allow even minority party members who are not ordinarily represented in the cabinet to initiate or prepare legislation and introduce a bill. And then further down, this is achievable by, amongst other things, interpreting section 57 as empowering the Assembly to make rules that do not constitute an inadvertent deployment of invincible giants in a member's path to exercising her rights in terms of those sections. Now again, we're not directly foursquare, but it's about whether or not that procedure, remember in section 12.3, the entitlement of an MP charged with contempt is the entitlement to a reasonable and a procedurally fair process. We say that because of the way in which the discretion afforded to the majority is unfettered, in the absence of an independent fact finder or the appropriate guidelines, you create the same problem here, that the entitlement is subject to the tyranny of the majority, and that's where the danger arises as addressed in EFF2. The second case I'd like to refer to is the matter, before I move on, at paragraph 67 of that judgment, I don't know on the internal page numbering.
Doesn't matter. We're fine.
Paragraph 67, you've got it. Thank
It's
you,
on
my
the
lord.
same page.
Is it the same page?
Yeah, carry
I'm
on.
reading from a note,
Yes,
so
yes, carry
I'm
on.
indebted.
Carry on.
About 5 lines into paragraph 67, let's see what they say about common sense. Common sense suggests that any majority party in the Assembly is likely to support its own legislative projects and not those of minority parties or any individual member. For this reason, a permission requirement boils down to a mechanism that is inescapably prone to deny individual members and minority parties the power to initiate legislation. So you know that how we read these cases is consistent with what they say in EFF 2 about the abuse of the discretion given to the majority. The second case I'd like to refer you to, and I mentioned it earlier, is Mazibuko, inadvertently I should say, is Mazibuko versus Sisulu. It's in that same additional supplementary authorities bundle at page 172. Now, again, what you'll know about this is that this was about the right of Ms. Mazibuko, or any MP really, to enroll a motion of no confidence in terms of section 102, and whether or not subjecting that to the programming committee was constitutional or not constitutional, having regard to how the programming committee functions and the majoritarian nature of the Assembly in deciding such a thing. I'm referring to paragraphs 57 and 58 of that judgment. And this is what the court there says. I agree with the High Court that a vital constitutional entitlement, and we say that the entitlement here is what stems from the Act in terms of the protection around a reasonable process and a procedurally fair one. The vital constitutional entitlement to move the motion cannot be left to the whim of the majority or the minority in the programming committee, or any other committee of the Assembly. It would be inimical to the purpose to accept that the motion may never reach the Assembly except with the generosity and the concurrence of the majority in that committee. So we say that the logic of the court in Mazibuko and Sisulu applies here, because you only get the entitlement if the majority is generous to you and decides that that's what you deserve in the exercise of their wide and unfettered discretion. And then remember, there was some debate that was raised by my learned friend, and Justice Davis engaged with that debate about, that was under the old ANC single majority. Now there is no majority, and how does that impact? Firstly, we say that that's no answer, because the court's judgments deal with majorities in general, not a single party majority. But look about what the court says in that same paragraph about minorities. It is equally unacceptable that a minority within the committee may render the motion stillborn when consensus is the decision-making norm. It would have been an easier matter for the Constitution to specify that scheduling of the motion is subject to political negotiations and so on. The point we make here is that what the Constitutional Court says in the context of motions of no confidence is that where you have the entitlement, that entitlement should not be left to an unfettered discretion from the majority or the minority, however constituted, where that has the effect of potentially breaching rights that you are otherwise granted. Obviously there, it's in terms of 102 of the Constitution. Here we say it's in terms of section 12.3 of the Act.
Can I just ask
Yes, Judge.
as a matter of principle, when one quotes judgments and puts up legal propositions, do the facts of the case in terms of which the propositions are located matter? In fact, I was taught that in first year law school. A ratio essentially is located to the factual context. There's a very significant factual difference between motions of no confidence or private member motions and a disciplinary structure.
Yeah, I'm happy to accept that.
Do you therefore accept that when one reads these submissions that you make, you have to take that into account?
Not to the extent that it operates as a bar from not looking at
Well,
how
the
the court
question
looks
is
at
whether-
majority,
Sorry,
how the court
sorry.
looks admittedly in
So
different...
let me just finish my point.
Oh, I apologize.
Does it mean that if you look at the structure of what we concern now and say that's very different, how does one then read the legal propositions you're advancing?
So you asked me two questions. The first one is about whether I accept, I can't remember what that was.
Well, we'll deal with the second one. So it's just related to the first. How does one read
Is
a
that the question
statement
about
of
the
law
facts?
in circumstances we say, well, I can perfectly understand what they're talking about in relation to a private member's motion or a motion of no confidence.
Yes.
The latter, which I know a lot about because that case started with me.
Yes.
Um,
I'm indebted.
what I'm asking you is, when you're dealing with the sort of context here of Parliament having a right to discipline its members,
Yes.
why would one automatically say the same principle applies?
I'm not saying that the same principle applies. I foreshadowed that the facts are different. All I said...
No, I appreciate that you said that, and I
yes,
appreciate
and you'll
that.
appreciate that I was saying
Yes, no, I
that
get that.
these different examples, EFF2, Oriani Ambrosini, and Mazibuko, all give direction from the Constitutional Court of how the Constitutional Court looks at the mechanics of majoritarian decision-making in the House under different regimes, and therefore this court cannot simply close its eyes to that analysis where we say that the same considerations apply. And that's as far as I can take it.
So let me then ask you the second point. In the light of the fact that the structure of the system, which is a committee and it's an internal committee,
Yes.
has not itself been challenged.
No.
Where does this fit in? Does it fit in
No.
in your attack on 12.5? Does it say that, okay, you've got the potential majoritarianism here, and that therefore means that what this court needs to do is be careful to ensure that that is fettered by virtue of the guidelines and the independent inquiry. Is that where I'm trying to work out where your submission fits in?
So the last part of your sentence I agree with in terms of the fettering point that you've just made. But insofar as the first point that you made to say that it's not challenged, that's not correct. If you call up the amended notice of motion, you'll see that in paragraph 6 of the amended notice of motion, the composition of the committee in terms of Rule 214 is challenged, but it's not challenged in the same way before the Ludlow Court was. It's challenged specifically having regard to inter alia, the absence of a separate fact-finding mission. And then, of course, the fact finder, yes, not fact finder mission, I apologize. And then, of course, that's enhanced by what is contained in Prayer 7, which is the further frontal challenge on the further challenge that's saying that the rules in any event don't meet the requirements of 12.3. So that's the answer.
Sorry, just a minute. You say, which
Yes.
one are you talking about now? 6?
6 years,
Yes.
not 6-1, was it?
Well, I'm just looking at where you say declaring the impugned rules, they fail to conform with 12.3a.
Yes, that's the
Which
additional
means
link.
12.3a is left intact.
Yeah, that's right, and we've never sought to attack
Well, the point
12.3.
and that's the argument that I think has been developed right throughout, is that 12.3a itself foreshadows the particular problem that you're attacking.
Yes, but remember then the second point of the sentence that you gave me, which is the one that I agreed with, is that that's when we trigger the issue about the fettering
Yes,
and the nature of the
I
discretion.
there I understand perfectly.
So
And
then
if-
we
if
are
you
ad
say-
idem on
so
that point.
are you? So no, I just want to make sure that I understand, not you. You understand your argument. I need to understand your
I'm
argument.
understanding the
What
question.
I want to ask you is, does that mean that if you're right,
Yeah,
and one would argue then that because of the judgments to which you've referred,
yeah.
the jurisprudence is extremely worried about the majoritarian
Yes.
problem. I'm just putting it
Yeah.
that way.
I think that's a fair
Therefore-
assessment of the argument.
Therefore, that means that when you seek certain inclusions, such as the guidelines,
Yeah.
inquiries,
Yes.
all of those should be read in, need to be there. And if
Yes.
they're not there, then...
Yes.
And is that why you've attacked 12.5
Yes.
effectively?
That's right. Well,
And-
to attack 12.5, but remember we also attacked 214.
Yes, but is the solution, therefore, your solution, that 12.5 is inadequate to bear the burden of the problem?
Yes,
of the-
yes,
is that
as,
what
as it currently stands.
That's what I'm just trying to locate.
Yes,
Really.
no, then we're speaking, we are directly ad idem.
Okay.
And that logic applies not only in
then you
respect...
can, I understand your
Yes.
argument, and we can move on.
It's not only in respect of 12.5, it's also in respect of Rule 214.
Yes, yes, all
And
right.
the difference, though, is that in terms of Rule 214, the grounds of challenge of 214 are specified in 6.1 to 6.4.
Yes, I understand.
Whereas the 12.5 issue is just the guidelines.
No,
here.
I've got
Okay, so then we are ad idem
So
on
we
that.
can move on.
Can I just say, I was reading from 57 in the Sisulu Mazibuko judgment. Can I just ask the court, when it's considering that judgment, to also look at paragraph 58 of that judgment? I'm not going to read it out because the points have been foreshadowed. I'm indebted. But Justice Davis, you foreshadowed the next argument I was going to make, which is about the kind of relief that we're asking for here.
Yeah.
Remember, what we're doing here is we're doing something similar to what the court did in the Glenister series of litigation. You'll remember in the first Glenister judgment, not the Langa CJ Glenister judgment, I'm talking about the Moseneki and Cameron Glenister judgment with the Ngobo J as CJ writing for the minority. What you'll remember is that the Amendment Act to make the Hawks, I'm sorry, I'm speaking very loose language here. If the court
doesn't matter, I understand what you're saying.
I hope the court is following the submission.
Keep going.
What happened is that the Hawks Amendment Act was attacked in the Constitutional Court on the idea of whether or not the mechanism as employed there met the constitutional notion of adequate independence. In that judgment, Justice Cameron referred to it inter alia as adequate independence or sufficient independence. And what they did is they invalidated the act the first time round on the basis of saying that the contents of the act, the schedule, the rules in our case, don't meet that threshold. And what we say the threshold is here is procedural fairness and reasonableness. So that's the first point about Glenister. And then what you'll remember what happened is after they invalidated it, the Amendment Act comes out 2 years later, which ultimately ends its way in the Constitutional Court. And remember in the Constitutional Court what happened the second time round, which is Mogoeng CJ writing for the full court, is they once again invalidated on the basis of that principle which they had interpreted to include certain features. But remember when the court handed down its order, it didn't specify what those features had to be. And the reason I mention that is because, Justice Davis, you'll remember yesterday there was a debate that we had. I think even Justice Fortain asked me a couple of questions about what the guideline would look like. What we're saying is that that's authority for the proposition that we don't have to specify what the guideline will look like. We're entitled simply to invalidate on the basis that it doesn't meet the threshold, because that is what they did in Glenister. So the modesty of the relief that we're seeking in this matter isn't even as far as in other matters where there are reading-ins that are being sought. We're saying it is properly within the preserve of the National Assembly, the National Council of Provinces, Parliament as a whole, to make its own rules, and that it would be improper for this court to specify what those rules should be. All we're saying is invalidate on the basis of the standard, and Glenister is authority for that. May I move on? Oh, yes. May I just, I'm going to refer to the textbook by Hoekstra, this one, which I'm getting indications that some members of the bench are very familiar with it. But the judgment I'm referring to is the judgment of Janse van Rensburg. The Janse van Rensburg judgment is in the additional supplementary authorities bundle. That's the one not in the file. It's the additional paper one.
Yeah.
And it's at pages 122 to 123 of the additional supplementary bundle.
That you're reading from.
Well, I'm not going to read from there. I'm just going to talk about what Hoekstra says first, if I may, Justice Fortain. Does the court have the judgment?
Yes.
Carry on.
Thank you. What you will, at page 65 of Hoekstra's textbook with Penfold, 3rd edition, Administrative Law in South Africa, she says, what she does is she talks about discretionary powers and the two types of discretionary powers. She talks about what is called mechanical discretionary powers, which is at first blush, a power may appear to be discretionary, but in truth it is not, because it requires you to simply tick certain boxes, and once you tick those boxes, you should get a favorable decision in your favor. That's what she refers to as mechanical or ministerial powers. That's like when you apply for a license that doesn't require an element of a value judgment. But the second type of discretionary power is the kind of discretionary power that the committee has here, which is a wide and an unfettered discretionary power, which is to determine matters as they choose, as and when they arise before them. And remember, this is the debate which Justice Davis and I just had about the fettering and the guidelines and the invalidation based on the principle, because she says this. She says, although the second powers seem to involve no duty at all, and we say that there's no duty at all here beyond the simple statement of procedural fairness and reasonableness, it is important to realize that the holder of the discretionary power never has a completely free hand. First, to act with discretion means to act wisely after due reflection, and so whilst discretion can be very wide, it can never be completely free, unfettered, absolute, or arbitrary, notwithstanding the frequency of these and similar adjectives which have been used by the courts. She references, I keep saying she, it should probably be they because it's her and Mr. Penfold. I don't mean to do an injustice to him. They refer in footnote 465 at page 65 to the Padfield judgment, which is an old judgment from the Court of Appeal in England and Wales, which I'm not going to take the court to. Instead, what I will ask the court to is call up the Janse van Rensburg judgment, and the Janse van Rensburg judgment, the relevant portion of that we rely on starts at page 122, paragraph 23, but the portions of the paragraphs that I'm going to rely on is 24 and 25. Now, can I just say that the nature of the powers is analyzed fully in paragraph 23 of the judgment, and the effect of those ministerial powers is analyzed in paragraph 23 of that judgment. Obviously, on the facts, we are in a different territory because that was the minister's power to make these decisions. But we're saying that based on the earlier discussion I had with Justice Davis, we're saying that the logic applies here. But the particular paragraphs we refer to are paragraphs 24 and 25. And what the court says, and I'm reading from the second sentence in paragraph 24, in doing so, it must be appreciated that one of the enduring characteristics of procedural fairness is flexibility. Sure, the application of procedural fairness must be considered with regard to the facts and circumstances of each case. In modern states, it has become more and more common to grant far-reaching powers to administrative functionaries. Can I just pause there to say that? Obviously, well, I think we've left the question open as to whether or not the committee acts as an administrative functionary.
Yes,
however, I think we can accept that when the committee acts pursuant to the Act and the schedule, it certainly acts in terms of a delegated power, the source of which is the statute and the Constitution. So we say that the position of the committee is akin to an administrative functionary who derives the source of their power in the same way. I'm reading on. The safeguards provided by the rules of procedural fairness are thus all the more important and are reflected in the Bill of Rights. Observance of the rules of procedural fairness ensures that an administrative functionary, we say the committee, has an open mind and a complete picture of the facts within which the administrative action is to be taken. In that way, the functionary is more likely to apply his mind. But then here's what it says at paragraph 25. Every conferment by the legislature of an administrative discretion need not mirror the provisions of the constitutional common law. However, as this court has already held, in the context of a limitation analysis, the constitutional obligation on the legislature to promote, protect, and fulfill the rights entrenched in the Bill of Rights entails that where a wide discretion is conferred upon a functionary, guidance should be provided as to the manner in which those powers are exercised. The absence of such guidance, together with the cumulative effect of the other features referred to in 23 above, rendered the procedure provided in the section unfair and a violation of the protection provided in section 33(1), which is a reference to the Constitution. We say we are foursquare in a similar territory, admittedly under a different statutory regime.
Is there a difference between that, again, and the fundamental proposition, which I think appears on the first page of your opponent's heads, the right of Parliament to discipline its own members?
But I don't understand what you're asking.
Well,
the fundamental
argument
differences
is that
in respect of.
essentially one should defer as a court to giving Parliament the scope to do that which it's inherently entitled to do, discipline its own members.
Firstly, there's no such single institution as Parliament. Parliament has two constituent houses, and the Constitution...
Well, I don't think that helps.
No, may I develop the submission before you tell me that with due respect? The point here is that Parliament is a composite institution made up of two different houses, the National Assembly and the National Council of Provinces.
Right?
Section 57 of the Constitution gives the National Assembly the powers to make its own rules and procedures, including delegating some of that power to a committee. So to answer your question, there is no fundamental difference because the act of the delegation renders the committee functioning in the same way that an administrative functionary does when a power is delegated to them under a statute.
I'm finding that extraordinarily difficult to understand. Are you saying that the submission made by your opponents that Parliament doesn't have an inherent right, which is perhaps articulated in the Constitution, to discipline its own members?
No, but that's never been my case.
No, but if that is the case, then is there not a fundamental difference between that and some administrative
No.
official, such as in the Trade and Competition
No,
Act,
there is no
which is what the
fundamental-
Janssen from
No.
Rensburg case.
There is no fundamental difference for the reasons I've already submitted.
Okay, if that's your submission, move on.
Thanks. The other judgment I'm going to refer to is ex parte Minister of Home Affairs, which is
that
in
going
that
to tell me
same...
the same thing?
I beg your
That's going
pardon?
to tell me the same thing.
No, it's going to be slightly different. May I read the judgment, perhaps? Thanks. At page 97 of the additional supplementary bundle of authorities, and I'll ask the court to look at paragraph 48 if it's minded to do so, because the point is not the same. The point is slightly different. And the point is about the criterion debate that we had a bit earlier. It's just to illustrate to the court that when we were having this debate about yesterday, about what the appropriate criteria is, in that judgment, the court said it was sufficient guidance that the criteria was as modest as good cause shown. Now, in this case, we're not even asking for that, but the point is to demonstrate that even that modest level of fettering of a wide discretionary power is what the Constitutional Court says is acceptable in our modern democratic state, based on the way in which public power is exercised. And then at paragraph 49 of that judgment, 49, 50, and 51, there's a development of those cases that we discussed yesterday, where the Constitutional Court again relies on Darwood and affordable medicines, but the court already knows what those judgments have to say about that. Justice Davis, I see it's 11:15. May I proceed?
We're carrying on.
No,
Thank
we're
you.
gonna-
Thank you so much. Then, can I make another point about the guidelines? This is my concluding submission on the first head of argument about the nature and scope of the relief. Remember, Justice Davis, there was a point you put quite pertinently to me yesterday about, well, if these breaches happen, can't you just review it? Why does it have to be constitutional relief as a point of principle? Can I ask the court, I've referenced Glenister already, but can I ask the court to go to the Glenister judgment at page 311 of the supplementary bundle of authorities? That's the file. Sorry, I've got you dancing all over, but I apologize for that.
That's Glenister.
What's the
Yes.
page?
311. The file, Justice Davis.
Okay, no, I'll find it. Carry on.
May I? Thank you.
Yeah, carry on.
Paragraph 247. Now, obviously, again, the facts of this case are different because that was about the power, the complaints procedure and the power of review where adverse decisions are made by the head of the DPCI, and whether or not that was good in terms of adequate protections for breaches of rights. And the court's logic here is what we rely on, because remember, Justice Davis, we were having the debate about the structure, and this is why the constitutional attack is good in our submission. Paragraph 247, in about line 6 of that judgment, the court says, in short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, in our case we say breach of rights, has in our view serious and obvious limitations. In some cases, irreparable harm may have been caused, which judicial review and complaints can do little to remedy. Now remember, Justice Davis, we were having that debate yesterday when you asked me about the difference between dismissal and suspension. And in the course of that debate, I said to you, if you're suspended over the period of the budget, if you're suspended over the period of an important motion of no confidence or whatever, and your suspension is ultimately found to have been unlawful, you don't then get the right to come back and re-vote on those issues that the National Assembly might have moved on from. So we say, and in debating with me, you said, Justice Davis, you accept that there might be some deleterious effects flowing from the suspension. And we say that because that is the most serious consequence that a person can be sanctioned for under contempt of Parliament, this authority is good proposition for the constitutional challenge on why we are insisting on a structure that better protects MPs' rights rather than less doing so. Now I'll move on to the constitutional relief, if I may. Let's start here. Firstly, our learned friend started talking about outsourcing, and he said that outsourcing, you've already heard my submissions on Lordlaw. I'm not going to go back there. But what I just want to say is the difference is that in this case, unlike in the Lordlaw matter, the Lordlaw J judgment, we're frontally challenging, and we're frontally challenging specifically on the basis that there's no provision for the outsourcing. And our learned friend, in referring you to the third portion of the preamble to the Act yesterday, emphasized that the purpose of the Act is to protect the authority, independence, and dignity of the legislatures. I don't know if he read it out yesterday, but that preamble goes on to say, and their members. And that's the point that we're making here. The point is that the structure that we're insisting on must be one that enumerates the protections for MPs, particularly minority party MPs, before they are subject to discipline in terms of that system. That's point number one. Point number two is that if you look at Rule 214, which is the functions of the Privileges Committee, it's in your pleadings bundle at page 75, if I'm not mistaken.
Yeah.
I think it's Annexure FA0, if I'm not mistaken.
Yes.
Yes, let's me get that.
What's it called?
Sorry, I apologize. The annexure starts at 75. The particular
goes
page I'm
on.
looking at is 78.
So just bear with me. Yes, please
Yeah.
carry on.
Yes. So it says, and just notice this, because remember there was also some debate yesterday about the Speaker and her decision and whether it was good or bad. Now, I'm not rehearsing any of that, but I just want to demonstrate that when the how the Privileges Committee triggers its investigation and its finding as it did here. If you read the first part of Rule 214, it says, the committee must consider any matter referred to it by the Speaker relating to contempt of Parliament or misconduct. And then it goes on to talk about other instances. But we are squarely within that first category, which is the referral by the Speaker. Now, what we say in the context of outsourcing is that that's important. Because remember, on the facts of our case, and you know what I've said about the majoritarian principle, the ANC Speaker handing it over to an ANC majority in the Privileges Committee is a recipe for disaster based on the authorities that I've referred to already. I'm not rehearsing that debate. But what we say is that outsourcing then serves as a fundamental check and balance on any abuse that may arise in the context of that system. And can I just say this? Is that, and the reason for that is because the committee here acts as both investigator, prosecutor, and judge when disciplining a member. And we say, absent the constraints, which we've debated already, that's not a good thing for the purposes of ensuring that the procedure is reasonable and procedurally fair. If you've got the Glodlaw judgment, that's in the file again, I just want to point something out to the court at paragraph 29 of that judgment.
Just give us
The file 236.
29, eh?
Yeah, 29. In that paragraph, you can see that in line 1, the judge starts with importantly bracket A. Will you find bracket D? It's about fourth from the bottom. We say that this is interesting. Because even though my clients say that the initiator is not independent, look at what the court says about the independence of the initiator and the importance of that. The issue of the charges was discussed and the legal advice was solicited. It was explained that the task of the committee was to decide, we say that that's what they must still do here, on whether the applicants were guilty or not. In those circumstances, it was considered fair to leave the task of formulating the charges to the initiator so as to avoid the perception of bias, political interference, and procedural unfairness. We say it applies a fortiori then insofar as the facts are concerned. The very schedule that we place in issue here as analyzed by
What is the bias? Just explain to me.
No, it's not the actual bias. It says perceived bias. The only point I'm making
But what
here,
is perceived bias?
No, hold
What-
on.
No, sorry. Please answer questions when I put to you.
I'm trying
Can I
to.
just ask you, what is perceived bias in this case?
You've heard my submissions on
No,
that
I'm
about.
trying to understand. You say that one must prevent bias and perceived bias. I'm trying to, in this case, on the factual context, what is that Mr. Malema's perception of Mr. Katz?
No, it's that the majority in the conduct of the proceedings had predetermined all the matters against him, and that's why he was not entitled to that's why not predetermination in the sense of a ground of review. That's not what I'm suggesting at all, but rather that the way in which the committee operates and as recognized on the majoritarian.
Is this generally?
Yeah.
So inherently, because of the majoritarian principle, there will always be bias.
Yes, but you know what my submissions are.
No,
on
and I know
that.
what their submissions are, so you can move on.
Yeah, but I wasn't finished on making the point that I was making.
Well, what was
so
the
may
point
I make
there?
the point?
Yeah.
Thanks. Anyway, the point that I was making is that if the same schedule which we're placing in issue here says that the role of the initiator, which introduces an alleged degree of independence, you know, on this case we say it's not truly independent, is done specifically for the purposes of ensuring that there's the removal of any perception of bias or political interference. That same logic applies as respect why the fact-finding mission should be conducted by an independent fact-finder.
Kinda.
Okay, we're back to that, all right.
It's the same. It's the same argument, basically.
Yes, I've just
Yes.
different variations, yeah. All right, let's move on.
Variations on the theme. I know Justice Davis is a fan of classical music, and that's something
Well,
that
that's
he-
true. At
Exactly.
least it sounds very nice.
Yes.
That's a different matter.
In my assessment, it sounds exceedingly nice, but be that as it may. Let's talk about Parliament's own conduct then in the context of these proceedings. I handed up to you the Rule 129
Yeah.
extract. Can you just keep a finger there before I start moving to that? And remember, the point that we're making here is that all of these cases that we're referring to, all of the analysis of the structure and all of the things that Parliament itself does favors the overall attack which we're making about the independent fact finder as a safeguard on procedural fairness and reasonableness. If you have, I don't know if you have a copy of the Constitution in front of you, but
No, just give me a...
I'm just going to read from section 194 of the Constitution, which is about the removal of Chapter 9 office bearers. And what you will know about section 194 of the Constitution with the removal of Chapter 9 office bearers is that it says, the Public Protector, Auditor General, member of the Commission established by this chapter may be removed from office only on, and I'm reading B, a finding to that effect by a committee of the National Assembly right? If you look at that Rule 129 that we handed up, you will see that the 129 rule provides for an independent panel before that committee then in turn makes the decision which triggers the process in the National Assembly. So you've got my generic principle point about the arc of justice, if I can use that term, but also specifically that there's no provision in the Constitution for the on-delegation, because it's the committee and the National Assembly, but the actual rules adopted by the National Assembly foreshadow the very type of structure which we're saying ensures reasonableness and procedural fairness. And I put it no higher than that. May I move on? And maybe it's related to the 194 debate, because remember, Justice Davis, yesterday there was another debate about same debate about difference between removal and dismissal. Can I ask the court to go to section 47 of the Constitution, that very famous section that Mr. Ngukaitobi argued recently in the Constitutional Court? What you will know is that section 47 of the Constitution is explicit in terms. It talks about membership of the National Assembly, and sub 3 of that section says, a person loses membership of the National Assembly if that person, A, ceases to be eligible. That's about their criminal conviction, whether or not they're an insolvent, and so on. It goes on to say, is absent from, and listen to this, is absent from the Assembly without permission in circumstances for which the rules and orders of the Assembly prescribe loss of membership, right? That's about absence. And then it says, ceases to be a member of the party that nominated that person as a member of the Assembly. So the point is that we can't talk about removal of members of the National Assembly outside 47.3. The point is that in the context of discipline within Parliament, the contempt of Parliament and ultimately the suspension under 12G is the most serious disciplinary mechanism. And so we say in this context, that's why the arguments we've made about procedural fairness and reasonableness apply. May I move on? I'll take silence as consent.
Yes.
Insofar as the second argument by my learned friend Mr. Nasiruddin is concerned, his argument on bias, I'm not going to rehearse it at any great detail. Can I just give the court some references where we deal with bias foursquare? It's in our heads of argument at page 51, not page 51, at pages 13 to 14, para 51.
Is this the main ones or the...
Main heads.
Main heads, yeah.
Main heads. Page 14, that's where we cite Safu. Page 14, para 52, where we cite Basson and Hugo. Page 54, where we cite Swane sitting in Africa. But whilst we're there, can I just pause to just highlight something in the context of majoritarian decision making and why the committee, absent an independent fact finder or guidelines, is open to the kind of bias that we talk about. In light of those three judgments which we analysed, EFF2, Oriani, Ambrosini, and Sisulu. I'm just reading from para 71 of that judgment, which is also at page 253 of the additional supplementary bundle if the court wants to turn it up. I'm reading the second sentence. For decision makers cannot be impartial if they stand to gain from the very decision taken by them. We say in the context of discipline in the hands of a political majority, you stand to gain by punishing your opponents, as the courts have recognized in a multitude of cases. And that's why the bias arises. It's not necessarily a personal bias, it's the very structure, absent any fettering of a wide discretion, that creates the problem of bias.
Can I just ask one question on that?
Of course.
Then we can move on. There was submission yesterday by your opponents that if you look at the record, in fact, these committees have found against their own members.
That's fine. That's no
It shows
answer.
that
Broken
well,
clocks are
it's
also
evidence.
right twice in the day.
No, it's evidence of the fact that you can't just simply infer
No.
inherent bias.
No, that's right. But remember, in the earlier, but that, and so what is
So
my,
what
is my
is
response?
what is that whereas you say inherently there's always bias,
yes, it's
their argument is the record
it's
shows that's
inherent-
not so.
It's inherent to the structure that opposition MPs are in a vulnerable position because of the majority control
Well,
of the
but the
committee.
interesting-
That the majority may act against its own members from time to time is neither here nor there.
No, but it is
It's
here or
about
there.
the structure.
No, but it is here or there because the argument is the structure. You see, there are two issues you have to consider here. Your argument is parties will always, in a sense, pursue their own agenda. That's the fundamental point. Strange that they pursue an agenda to kick out their own people, but that's
Yes,
another
because
matter.
factional battles don't happen in the reality
Well,
of
I'm
our
not sure
politics all the
that
time.
for
But
us
be
to
that as it
read
may.
that, I'm saying that the evidence suggests that that's not entirely true.
Well, I'm not sure about that, but
Well,
be that as
I'm
it
not
may.
sure about that. You haven't put up evidence to suggest that that's wrong.
Fair.
Secondly, the argument is that fundamentally we've been debating two things. On the one hand, it's, well, parties will pursue their sexual interests. On the other hand, the members are enjoined to follow the Constitution.
Yes.
And the question is which actually wins out here. If the evidence suggests that the constitutional component wins out, where does that leave you?
The constitutional component being
Meaning
the
that
loyalty to
they
the oath.
follow the constitutional dictates and are pretty
Yeah, but that's
fair.
a fantasy land with respect.
But it's
a
not a-
fantasy. It's a fantasy land with respect because it ignores the structural reality that the Constitutional
the
Court has
structural
already
reality- but
recognized
if the
in three
structural-
judgments
Sorry,
about majoritarian
just
decision
listen,
making.
if the structural reality indicates to a contrary consequence to yours,
No,
why,
but it does. No,
why
but it
is
doesn't.
that fantasy
Because
land?
no, remember it doesn't because in the secret ballot judgment, what was recognized in that judgment is that party leaderships also have the ability to weaponize discipline against their own MPs if they vote against their own parties.
Well,
so the
that
point
wasn't-
is that
that's-
party leaderships are
that's
not as
not the
beneficial
evidence here.
as they're
That is-
suggested to be.
But sorry, with respect, that isn't the evidence. You know, one of the difficulties we're having is I'm trying to keep to the facts, not to fantasy land, as you would call it.
Yes.
And the facts are quite ambivalent in this regard, and that's what I'm trying to put to you. But okay,
I don't have to.
I've
I
got
don't have to. But I don't have to argue an absolutist point. I'm saying the
Well,
fact
you-
that the presence of the danger of the
I
structure.
thought your point was totally absolute.
No, that's not my case at all, despite the attempts to make it so.
Well, all right. Okay, move on. Because you've got 38 minutes left.
Yes, and I intend to make progress. So you've got that submission. Can I just also say that there was, Justice Davis, in the context of the debate you were raising yesterday about the polycentricity of the difficulty of any order that you give and the practical effect. Based on what I said earlier in Glenister, you don't need to go that far because we're not asking you to specify or read in or to make any of that kind of choice or that kind of delegation to Parliament. The second answer to our learned friend's separation of powers argument comes from Bartow Star. Because remember, Bartow Star, para 48, which you can find in at page 67 of the supplementary bundle, which is the file bundle.
one,
The
yeah.
file bundle,
What is it you want to refer to?
48, para 48,
Yes?
page 67 of that bundle.
Yeah.
It's that and I'm reading from line 3, a court should be careful to not attribute itself superior wisdom, I suppose despite temptation, in relation to matters entrusted to other branches of government. A court should thus give weight to findings of fact and policy decisions made by those with special expertise and experience in the field. What we say, because of the quasi-judicial nature of the disciplinary function, parliamentarians have no such special expertise and experience. The extent to which a court should give weight to these conditions will depend upon the character of the decision itself. And what we know is where there's a disciplinary decision that is being made, potentially with punitive consequences, that's where the obligation for it to be procedurally fair and reasonable is concomitantly higher.
That's why your opponents put such emphasis on the notion of Parliament to be able to discipline its own members as being the inherent mischief we're talking about.
But it's the unenumerated protections which then is the answer to that submission. Can I just say that we did put up contradictory evidence about when the committee disciplines the ANC. The reference is replying affidavit, page 888 at para 60.
Yeah, I like that.
Anyway, but that's neither here nor there.
Yes, it's not. Yes.
Yeah.
But it was raised and I've answered, so there you are. Anyway,
Where are we in your argument?
I'm still on the issue of bias
Yeah.
under the main heading of constitutional relief.
Yeah.
And in that same paragraph I was reading in Bartow Star, towards the end of that paragraph, this does not mean, however, that where the decision is one that will not reasonably result in the achievement of the goal, or which is not reasonably supported on the facts, or not reasonable in light of the reasons given for it, a court may not review the decision. A court should not rubber stamp an unreasonable decision simply because of the complexity of the decision or the identity of the decision maker. That's the point. So it doesn't matter. There's no special deference to Parliament. May I just highlight that in the context of the oath, which is something that we just discussed, even though the court in the UDM judgment says that in the event of the conflict between upholding constitutional values and party loyalty, their irrevocable undertaking is to in effect serve the people and do only what is in their best interest must prevail. But we know in reality that's not how public power, particularly at a political level, is exercised all the time.
Well, I think this is bringing us back to an earlier argument.
No, sure, I was just highlighting.
I'm not going to traverse
Yeah,
that.
no, I'm not
No,
either.
no, please move on.
Yes, thank you. The third head under this argument is discretion, which my learned friend dealt with. I think I've dealt with that
Yes,
already.
you have.
I don't need to say anything more about that. Can I just say that in the context of the time bar, because that was an issue, the time bar is not about the notification for the hearing, the 5 clear days. The issue about the time bar is the delay from when the incident occurred.
We're going to have to evaluate
Yes.
that in terms of the
And
chronology.
Can I just give you a reference to a case that might be helpful in when you do that? Page 213 of the additional supplementary bundle, the matter of Stockwell in the Constitutional Court. Admittedly, that was in a labour proceeding. The paragraphs we rely on are paragraphs 41 and 72. And when the court considers that, the court will see that there's various factors that are taken into consideration coming from the older judgment in Murinyane about whether or not the unreasonable delay disciplining after an unreasonable delay amounts to an abuse. And we say that
you're
we're
raising
raising
it
that.
because you think
That-
it was meant to prejudice.
Yes,
or to
exactly.
deliver.
Particularly,
That's the basis
yes,
of your
particularly
raising it.
remember because of the time sensitivity of when it happened, which was in the run-up to the election. But it's the issue.
What paragraph
there
in
was-
Stockwell, sorry?
The 2 paragraphs, 41 and 72.
Thank you.
Thanks.
Right.
Thank you. All right. Can I just talk about the review very quickly? This was what my learned friend Mr. Bishop spoke about.
Before you get there, could I just ask you this point in relation to Bishop's submission?
Yes.
One of the submissions he made was you've never attacked the substance, only the procedure. Do you agree with that?
Yes.
I think I got him right. I mean, he's not inside.
Yes, but I mean, that was the headline that he stated, but he
No,
didn't
I'm
develop
asking
it
whether-
any
no,
further.
no,
So
but
at
didn't
that
you
level,
agree with
so
me
that,
when
at that level I agree
You
with it,
agreed
yes.
with me when I asked whether it was only
So
procedure.
this is
Yeah,
not.
I
This is
agree.
not about the substance of what happened. It's about the procedures. That's your attack.
On the one leg, and then the other is
What's
whether, in terms of the rationality standard, it meets either procedural fairness and
No,
reasonableness.
I know
Because
that. But
remember,
there
it's
are
the
there are
two things
consequences
together.
about the substance, but I'm not going to go there. I just want to make clear.
Yes.
Carry on.
Okay. So I've made the first point under the review relief, which is about the standard of review. This
Mhm.
court says rationality,
Mhm.
looking at whether or not the decision maker did something which
Yes,
is,
we've got
amounts
that.
to that.
We've got that submission.
Fine, thank you. Just on the issue about whether Parliament is a court or not a court, because the suggestion was made that Parliament is not a court, we say that doesn't matter. We know that the authorities about the functions of domestic tribunals are long. They come from a long line of cases which speak about the importance of natural justice, and we say that. So even though Parliament, yes, is obviously not a court, that does not absolve itself of the responsibilities to ensure that natural justice is done for the reasons we've argued in terms of procedural fairness and reasonableness. But remember, our learned friend must also make a choice whether Parliament is a court or not a court. Because when he was arguing about the postponement, he said, oh, it's the same kind of discretion that a court exercises, and so the ability for an appellate court to interfere is concomitantly lower. So I think that they must make an election there about what it is they
I'm not
actually
sure
say.
that follows, but I'm not going to debate.
Be that as it may, thank you. Third point, under separation of powers, our learned friend, referring to the Doctors for Life judgment, emphasized para 37 of that judgment. We would ask the court to look at para 38, because para 38 is foursquare in support of what we're asking this court to do. You can find para 38 at page 34 of the additional supplementary bundle of authorities. So that's the paper one we handed up earlier today.
Page?
The paginated
24.
page of the authority bundle is 34, and the paragraph is 38. It's nothing new, but it
Yeah,
it
no.
contextualizes the separation of powers argument that he was attempting to run yesterday.
Yeah, well,
I beg your pardon, Justice Davis?
I'm not sure the one and the other follow. Anyway, it doesn't matter. I'm not going to debate that with you. I'll read it again.
I'll be indebted to you if you do so.
Oh,
Anyway, let's move on. There were some comments made about the Boris Johnson report yesterday and Kangaroo Court and whatever. Can I just say that the material difference there is that where that supplementary report referred to in the extract read out by my learned friend yesterday was in respect of other MPs, not before the committee, who were trying to undermine the position of that committee. No one's done anything remotely similar here. They've just challenged the committee's conduct on the failure
I'm not sure.
of reasonableness
I'm not
and
sure that
procedural
exactly the
fairness.
points that. Sorry, all those points about kangaroo court, etc., are almost taken word by word. They were the same. I mean, what he read out was the same as what Mr. Malema said.
Yes, but the facts of that report and who was saying kangaroo court and what they were doing, which gave rise to the supplementary report, is different. That's all I was saying.
All right. Okay.
That's all I was saying.
you wait for your
All right,
resolution.
fair enough. I don't.
Thanks. Anyway, on the issue of a single hearing, all we'll point out, remember there was this issue of whether or not the
The
hearing
whole thing is one.
is
yes.
one or the other.
Yes.
Can I just ask the court to turn up the charge sheet, please, which should be in volume 1.
Page 50.
Look, the one I'm looking at is at page 97.
97.
Yep.
Yes.
Just look at what they say at paragraph 11 at the bottom of the page. At the conclusion of
Well,
the
this is not the
hearing,
charge sheet. Isn't this the guidance or something that they notice of a hearing? That's what it is. It's not a charge sheet. Charge sheet is earlier.
no, the charge sheet is after. The charge sheet is the
Well,
Annex
a
A.
couple of yes, but I'm saying what you're reading is the notice of a hearing.
Yes.
Yeah. The charge sheet is attached.
Sorry, did I say charge sheet?
Yes, you
oh,
did
I
say
apologize.
charge sheet.
Sorry, I apologize. That's
Yes.
So we're looking
that's a
at
misstatement of mine. I'll
Yes,
correct
yes.
the record if I need
Yeah,
to.
you don't
I'm
have to
talking
amend
about the
anything. I
notice of the
understand
hearing.
what you're saying.
Is
Carry
that
on.
sufficient, Justice Davis?
Carry on.
Thank you. Anyway, the point I was making is in paragraph 11 at that page. Look at what they say. At the conclusion of the hearing, the committee will decide as to whether or not the allegations against you have proven. So at the end of the hearing, they'll decide whether or not the allegations are proven. And what happens thereafter? They say, if so, an appropriate penalty or sanction will be imposed upon you. So in other words, the very notice of the charge sheet or the notice of the hearing is consistent with the structure that we submitted to you yesterday, which is that the hearing in clause 8, which is about merits, concludes, and then there's a separate obligation when it comes to
I
sanction
don't read
in
it
terms
that
of
way
clause
at
9.
all. It just says, if so, an appropriate penalty could be happened immediately thereafter.
Yes, but
I
then
mean, the
why would it
words
say at
don't-
the conclusion
the
of the
words
hearing?
don't- the
It
words-
doesn't talk about the hearing, but the
Sorry.
sentence...
Sorry, carry on.
Are you okay, John?
I'm perfectly okay. Carry
Okay,
on.
good. I'm glad.
Yeah.
But then why would it say at the conclusion of the hearing the committee will decide? And then if so, the further leg will happen. We're saying that the very notice fits the wording that we contended for yesterday in terms of the clause 9 obligation, which is a must,
All right.
which cannot be a single hearing.
Okay.
what should we look at the definition in the schedule, or should we look at
What definition, my lady?
of what hearing is? That's
There
what
is
we're
no
doing.
definition.
No.
If you find one, that would be very helpful, but that's why we're having this debate
what
right
should
now.
we make of that, I'm asking?
Yeah, the absence
follow-
of the absence of the definition then adds favour to what I'm submitting about clause 9, which is the more preferable interpretation, because that advances the rights of my clients rather than restricts
That
them.
may be, but paragraph 11 surely doesn't actually add anything to it. It just simply says, that if so, an appropriate penalty. I don't know whether that could be right then and there. It could be on the same day.
You've
There's
had my
nothing.
submission.
Yeah. Well, I know I've got your submission. I'm just simply
Thank
saying
you.
I don't think that adds. Carry
Okay,
on.
that's fine.
Move on.
Thanks. On the issue of postponement, you've heard me. On the issue of the sanction, you've heard me. Can I just say that there was reference to Tshwane City versus AfriForum yesterday? Our learned friend relied on that and said, they didn't. I think the argument was that in the absence, the argument was that when the committee was asked for a postponement, they were under no obligation to grant it, despite the attempt to intervene in the other litigation, which my learned friend then described as a tactical ploy to delay proceedings or whatever the case might be. Can I just say 3 things about that case, which he relied on as authority for the proposition? Firstly, that was an interdict case, not a postponement case, so we're dealing with an entirely different legal standard. Secondly, in that case, the reason AfriForum didn't succeed is because they failed to meet the higher test of irreparable harm needing to be shown under an interdict test, whereas we say that for a postponement, it's a slightly lower test, which is good cause shown, as it can be understood in colloquial parlance. And we say that in the context of that application, where the pending litigation could have resolved a material legal issue as to the conduct of the hearing that the committee was hearing, they should have granted the postponement. And so Tshwane City is of no authority for that. And the third point that I just want to make is, if you want the reference to it, this is explained in Erasmus in the commentary, which is in your additional supplementary authorities bundle. I don't know if the judges get Erasmus and if they get law reports.
We get
anyway.
nothing in it.
Luckily, no.
Well, pages 82 to 88 if
Thank
you'd
you
like
very
to.
much.
And then on the issue of Mr. Faso, you know what our arguments are about his opinion evidence. He wasn't entitled. The only point that we would make is that if the committee had the appropriate guidelines as to the exercise of its discretionary power in terms of things like standard of proof and evidential tests and all those kinds of things, what the committee could have done potentially is drawn an adverse inference against the initiator per se to call the available witness. And we say that that has a material impact on the procedural fairness and the reasonableness of the
Isn't
hearing.
that where this question of not attacking the substance comes in? Because if there's no dispute about what was going on and the substance, the actual substance of the conviction, then where does that leave you on that? What more evidence was required? If you're saying not disputing that component, You follow what I'm trying to say?
No, I don't. I follow that element. I'd like to hear
What,
more of
what
what
I'm
you're
trying to say is, if this issue is other, what other evidence, etc., what other evidence would have been required? If you don't argue that you're not putting in issue the substance of the complaint,
I hear
then
what
I'm
you're
not
saying.
entirely sure why
Yeah.
you could argue
No,
that
just,
they needed
this
more
is-
people.
Maybe to borrow your phrase, let's try and short circuit this. The point is here is that, remember, Mr. Kaso's evidence in front of the committee was only about the rules and how they operate.
Okay.
No one led any evidence about the threatening element, whether it was the
Yes,
debate.
but
What
that's
we
about
part
the
of-
video?
Whether-
But that's part of the
hold on.
substance.
Hold on. Whether it was the debate issue that we were having yesterday about the president and the speaker themselves being threatened, or the objective assessment, the point is, my Lady Justice Fortain, is that the only evidence that was led from Mr. Kaso was about how the rules operate. No one, he cannot
But I
he cannot
asked you
speak.
yesterday whether it was common cause, what happened there. It's common cause.
The facts are
not in
no,
dispute.
but on what basis did the committee convict then? Because who was the witness who then came and gave the evidence about
Well,
the
then wasn't
threatening
it for
manner,
you to-
about the threatening manner of the conduct? That's the point.
That is precisely. I'm so sorry. Please go.
Are you correct to say that he did not testify about threats? Didn't he testify about feeling taken aback?
Don't put it into issue.
Pardon, my lady.
I think he said something about being taken aback by the whole situation.
Yeah, but remember what he says when he gives evidence in front of the committee. If I can ask the court to turn to page 245 of the record.
Yeah.
No, sorry, it's not 245. It's
About him
246.
not knowing
It's
whether
two-
they felt. Yeah, we read that. We read the evidence.
But
Yeah,
no,
we read the
but in
evidence.
direct response to Justice Nsibeni, it's at page 246 FA18, which is the submissions in front of the committee. He says, I just express my view on the application of the rules. So whether he's taken aback, not taken aback, views it as threatening, not take it as threatening, doesn't matter. And that's the point then about the
But is
guidelines and how these tests apply in the context of the
I'm
hearing.
sorry to press you on this, but if the substance of the complaint is not placed in issue, then I'm not sure how it behoves you at this particular point to argue this.
No, but remember that's because of that relates to the constitutional attack about the substance of the procedure followed by the committee and the implication of the inadequacy insofar as the fair trial rights are concerned.
Yes, but with the component, well, see, again, that really troubles me, because if you're not putting in issue, well, how on earth could they have convicted my clients?
Mm.
Then why is that relevant? Isn't that an own goal on your part?
No, but we are we are putting it in issue to the extent that that's one of the grounds that foreshadows the constitutional attack.
Which is, sorry, just tell me that again so I can understand.
So, do you have the amended notice of motion in front of you?
Yes, yes, yes.
If you look at 6.3 of the amended notice of motion, that's where we put the conduct of the substance of the committee's conduct in terms of the extant rules applicable to them
But
and the
all of those
instruments
relate to
frontally
procedure.
challenged.
All those relate to procedure.
Yes, that's right. Because remember, the entitlement in the statute is procedural fairness and reasonableness.
So therefore, essentially, my sister Fortain's proposition to you that, in effect, the facts are common cause has not been placed in dispute. Because that
But
would
we-
mean
no,
that you'd
but
have
we-
to say,
but
then
we-
you would have had to say,
but-
you know, I don't understand how this committee could possibly come to this view on the substance. That's my difficulty. Is that not a jurisprudential own goal? I mean, it's a very serious point I'm raising because it flows. Not onto all of your submissions, I grant you that. It doesn't flow, but it does have an implication, which is why I suspect Mr. Bishop pressed the point.
May I just take a
You
moment?
can
I'm
take
being
as long as
handed
you like.
notes and I
Please. No, it's
don't
an
know what the
important, it's an
Yes,
important
yes.
point, and I want your submission.
We've got 5 minutes.
So on the context of the evidence point, which is about this procedure substance
yes.
debate, it is raised in the founding affidavit. It's raised at pages 40 and 41.
Sorry, we get there. Let's just have a look.
sorry, I'm being told it's 40 all the way through to 47.
Yeah. Okay.
Oh, yes, all right. There's all this stuff about free speech, etc. But the fact is that it's not really in the relief you're seeking.
No,
That's the problem.
The free speech thing is not in the...
No, none of that
sought.
is.
Yeah, no. The only point that I think I would highlight is that in the context of the evidence advanced in front of the committee that was relied upon is what is said at paragraph 88. The sole evidence is the video evidence because Mr. Casso is only about the rules, not being authenticated, and then there's all kinds of other issues.
All right,
Yeah,
okay.
we've got that.
That's
Okay.
the,
All right, that's your point.
That's
Okay.
the strength of the submission.
Yes.
All right, so we've got...
Yes.
Yes,
Last point.
Yes.
The last point was this issue about the... Oh, we're making good
No,
time.
okay, keep going. Don't worry about your watch, keep going.
The last point was about whether or not the answering affidavit could advance reasons for the first time in the absence of the Rule 53 record.
Yes.
That's not correct, because remember how the determination of the decision is made, absent when separate reasons are given, is it's linked to the contents of what otherwise might constitute the Rule 53 record, which is the contemporaneous documents at the time. In this case, the reasons of the committee are contained in the committee report, and that's what the committee's decision, as it's handed over to the National Assembly, falls and dies by. Make in respect of the committee report, and I think I might have read it out yesterday, but if I haven't, I'll read it out again. In the committee report,
Yes, we've got it. Carry on.
in the committee report, the point I'll make is that you'll remember Mr. Katz, in his role as the initiator, says 10-day suspension and apology. The committee says, I did read this out yesterday. The committee then says, oh, we're very persuaded by what you have to say, and then summarily reaches for the worst of those sanctions, which is the 30-day suspension, without providing any internal reasoning there as to why they departed from what the initiator did. So the point is that that's the breach of the 12.5 and 12.9 obligation read together, because before you go there, you have to satisfy yourself that that's the appropriate sanction in the absence of everything else.
Isn't it a proper Rule 53 record? Why can't they put it in the affidavit?
No, they can, but remember, my learned friend submission was a bit different yesterday. It was that he could advance the reasons for the first time in the answering affidavit. And what I'm saying is that you can't actually put a new gloss on the committee report where the committee report is what it is. And that's the point that I'm making.
Got you.
Can I give you 3 references in respect of that? The first one is the Turnbull-Jackson case. I'm not going to read these up.
Yeah, please don't.
Thank you. 227 of the additional supplementary bundle, para 37. Second one is Crickler's judgment in Jockey Club, 1993. Oh, sorry, it's in the authorities bundle. If you'll give me a moment. It's at page 273 of the authorities bundle, and we are reading against 660D.
Para?
Paragraph.
No, it's the old style of reporting. It's no paragraph number. 660. We're relying on. Well, D starts it's slightly above, which is not relevant, but D to I.
Yeah, that's fine.
Okay.
And then the last one is another Johannesburg City Council decision, which is in your bundle at page 128 of that same bundle, the additional supplementaries bundle. And the reference there is it's at 91, and the letters are G.
Is that paragraph page?
No, it's the old
Page,
reporting.
page,
So it's
okay.
page
Yeah.
91
Yeah.
against the letters G. Then I can't find the letter. Where
Doesn't matter, I'll find it.
G, it's G, and I
From
would say
G
read
onwards.
up to the end of that sentence, which goes on to page 92.
Yeah.
That's it. G. So let's call it 91G to 92A. to give guidance. May I take an instruction?
Yes. So,
May I just refer the court in the context of the procedure and substance debate also to the relief sought in paragraph 9 of the notice of motion under the review head of relief.
Okay.
Okay,
all of 9,
yes, 9 and the subs.
yeah.
Unless there are any further questions?
Yes, there is.
There are others of the
So let me ask you the following. Let us assume, for the purposes of debate,
Hmm.
that you are correct that not so much when it came to conviction, but the sentence point, which is the point you, I mean, obviously there are all sorts of arguments,
Yes,
but,
yes.
but assuming that that one,
We're just focusing on sentences for the time.
assuming that one's
Sanction.
right because, for two reasons.
Yeah.
One, because there should be guidelines, as you
Yeah.
argued. Two, there are no guidelines.
Mm.
Three, your submission this morning, well, there are no reasons given for why they're
No
up
proper
the
reason,
ante.
yes.
Okay? Assuming you're right on that, but on nothing else. Right? That's what you're right on. What is this court supposed to do? Is it supposed to remit it back, and then who does it remit it to?
Which,
Do you follow what I'm trying to say? If you come to a point where you say, they were properly convicted, we can't find that we should set that aside at all. But on the other hand, Mr. Premierhead has made a good point in relation to
Yeah.
the fact of guidelines and sentencing, and that's all wrong, and therefore he's right on there's merit in those submissions. What are we supposed to do then?
Well, if you...
Because then you've got the anomaly, sorry to interrupt
Yes,
you,
sure.
we've got the anomaly then that we would have found that the conviction was proper but the sentence wasn't, if I can
Yes.
put it that way. What are we
Yes.
supposed to do?
Well, the default position is review and set aside. If you remit to the decision maker, then the decision maker must
So we could
do whatever he wants
we
to.
remit the sentence aside but the conviction would stand, which makes it bizarre. I mean, something's got to happen then.
No, not potentially, because you know, for example, in criminal proceedings, sometimes if a convicted person appeals against both their conviction and their
assuming
sentence,
uphold the,
sometimes
no,
the
no, with
conviction-
respect, uphold the conviction.
Yes, no, we're not talking cross purposes. The point I'm making to you is this.
Yes.
The point I'm making
Yeah.
to you is that the conviction may be upheld, but we know as a matter of course that
sentence can be reduced.
there you are.
Is that what
So
Or
what do you-
the sentence can be reduced by the appellate court, but obviously in this scenario it would go back to the decision maker.
Well,
to
that's
impose
my
a
point, but
sentence.
which decision maker now? I mean, the
Well,
old one is gone.
No, remember, it would have no. It would have to go back to the. It would have to go back to the privileges committee, however constituted.
To a new privileges committee.
However constituted.
Okay. I'm
Yeah?
just asking.
And then they, because they bear the obligation to make the recommendation.
Yes,
they must
and
then
then
make
have
the
to go back to
recommenda- and
Parliament.
then- Yeah.
Okay, all right. I
That's-
just wanted to know what,
Yes.
because I'm just trying to get the full picture,
Yes.
so you appreciate that if that
Yeah.
was the case.
No,
All
no.
right.
If you're against me on conviction, but you're with me on sentence.
Yes, that's what I was
then,
asking.
Yeah. No.
Okay.
Then that would be the process
All
to
right.
follow.
Okay.
That would be the
No,
process.
fine. I know you've answered my question. Thank you. Anything?
No, you don't want to hear.
Thank you very much. We've
I'm
managed-
indebted to the
Thank you
court.
so much.
All right.
8 minutes to spare.
No, you've done really well. You get a benefit bonus for that.
I'm indebted.
But you can
Justice
charge for the extra 8 minutes if you
Davis.
would.
No, I'm charging for the whole day. You can bet that I was reserved for the whole day.
Well, that's not my job to
Yes,
tell
no,
you what to
absolutely.
do.
Thank you.
I mean,
Thank
you've had
you.
a hard enough time. You deserve that.
Thank you, Justice Davis.
All
I'm
right.
indebted.
The court's indebted to counsel for very helpful submissions, which obviously take time to consider.
Yes.
We're adjourned.